Congresswoman Jasmine Crockett stood beneath the bright lights of the CNN studio, her maroon suit radiating confidence and calm. Across the room, Harvard Law Professor Emeritus Alan Dersowitz, the 85-year-old legal titan known for his courtroom brilliance and celebrity clients, shuffled a stack of papers as he prepared to make his case. His expression was firm, his movements deliberate, his confidence unshakable. "I have the evidence that will expose the Congresswoman's lack of legal understanding," he announced to the moderator, his tone dripping with certainty. "She may be a rising star in her party, but tonight, viewers will see she is far out of her depth." The audience stirred, phones raised, eager to capture what promised to be a fiery televised duel between generations, experience versus ambition, the establishment versus a new voice. Yet, across the table, Congresswoman Jasmine Crockett stood unflinching, the former public defender and civil rights attorney, now a freshman member of Congress, met his gaze with quiet strength. Those who knew her recognized that faint, knowing smile. It meant she was ready. As the cameras rolled, CNN host Rebecca Mitchell began the evening's debate on the Voting Rights Protection Act. Both contenders kept their eyes locked on each other. Dersowitz, with his decades of influence and courtroom victories, appeared poised for an easy win. But he was about to learn that underestimating Jasmine Crockett would become one of his most public mistakes. "Tonight," Mitchell began, "we're joined by two distinguished legal minds to debate the Voting Rights Protection Act currently before Congress. Harvard Law Professor Emeritus Alan Dersowitz, who has argued before the Supreme Court and represented clients from O.J. Simpson to Jeffrey Epstein, and Texas Congresswoman Jasmine Crockett, a former public defender and civil rights attorney. Dersowitz, dressed in a navy suit that radiated old-world prestige, adjusted his glasses. "Thank you for having me," he said, his Boston accent crisp. "I've been teaching constitutional law since before the Congresswoman was born. The public deserves to hear from someone who truly understands the legal complexities at stake." The condescension was unmistakable. He flipped through his highlighted notes, prepared to dominate through intellect and pedigree. Crockett, meanwhile, remained poised. At 43, her background was far from ivory towers, forged instead in courtrooms defending ordinary citizens. Her maroon suit shimmered softly under the studio lights, a golden necklace glinting at her collar. "Good evening," she said calmly, her voice carrying the firm, measured cadence of Texas. "Unlike some, I'm not here to lecture Americans from an ivory tower. I'm here to talk about legislation that affects real people, voters I've represented both in court and now in Congress." The host smiled, sensing the tension rising. "Let's begin with the fundamentals. Professor Dersowitz, you've called this bill an unconstitutional overreach. Congresswoman Crockett, you co-sponsored it. What's truly at stake?" Dersowitz leaned forward, seizing the floor. "What's at stake," he declared, "is a constitutional balance of power. The Congresswoman and her colleagues want to put elections under federal control, even though the Constitution clearly reserves that power for the states. This is poor policy and unconstitutional. I'm surprised anyone with a law degree would endorse it." Crockett's lips curved into a faint smile, not of amusement but recognition. She'd seen this tactic before. The dismissive tone, the assumption of superiority. Her team had studied his debates, noted his tendency to interrupt, to lecture rather than engage. What he didn't know was that she had spent the weekend reviewing his old academic essays, writings from the 1970s that contradicted the very arguments he was making now. She even spoke with his former students, who provided insights into his debating blind spots. "Congresswoman," Rebecca said, "your response to Professor's constitutional concerns?" Crockett nodded. "I'd be glad to," she began. "But first, viewers should understand something fundamental. Interpreting the Constitution isn't the privilege of Ivy League professors. It belongs to every American, especially those most affected by its application." Dersowitz raised an eyebrow, ready to interject, but Crockett pressed on. "The professor implies that I misunderstand constitutional law. Let's clarify. Article 1, Section 4 explicitly grants Congress authority over federal elections. The 14th and 15th Amendments further empower Congress to protect voting rights. That's not abstract theory. It's written law." Visibly irritated, Dersowitz countered. Congresswoman, I'm fully aware of those provisions, but the Supreme Court has consistently affirmed state control, most notably in Shelby County versus Holder. I know Shelby County well, Crockett replied. I litigated cases directly affected by it. The question isn't whether states have authority. It's whether that authority can be misused to silence voters. Dersowitz frowned. That's exactly the emotional appeal that clouds this debate. The Constitution guarantees equal protection, not voting convenience. Crockett leaned forward slightly. When voting restrictions disproportionately burden specific communities, she said evenly, that's not about convenience. That's about constitutionality. The control room buzzed with excitement. What began as a policy discussion had evolved into gripping political theater. The clash of eras, of privilege versus perseverance. Rebecca Mitchell turned back to Dersowitz. Professor, you've also criticized the bill's requirement for minimum early voting days. Why? Because of the federal overreach, he snapped. States differ in population and resources. A uniform rule undermines federalism and creates chaos. Election officials in 17 states have warned this will cause logistical nightmares. Crockett's expression didn't waver. She reached for a pen and made a single note on her paper. Whatever came next, it was clear the old guard was facing a new kind of challenge, and Jasmine Crockett was ready to redefine the debate. The Congresswoman's proposal prioritizes ideology over practicality, Dersowitz declared. Crockett waited patiently before responding, her composure unbroken. Interesting that you cite election administrators, she said coolly. I have statements from 23 states, several led by Republicans, supporting these standards as both realistic and essential. She turned toward him. Let's discuss consistency, Professor. In your 1982 book Rights of the People, you wrote that federal voting standards may be necessary when states demonstrate ongoing discrimination or failure. You even endorsed national early voting requirements. Tell me, has the Constitution changed or merely your position? A flicker of surprise crossed Dersowitz's face. He hadn't expected her to quote his own work. Shuffling his notes, he replied stiffly, academic perspectives evolve with time and evidence. The voting landscape has changed since the 1980s. So constitutional principles shift with political climates? Crockett countered. That's an interesting stance for someone claiming to be an originalist. The tension in the studio grew thick. Host Rebecca Mitchell stepped in, redirecting. Let's move to voter identification laws. Critics argue that your bill weakens election integrity. Those critics ignore the data, Crockett replied. Multiple studies, including from the Brennan Center for Justice, show voter impersonation fraud is virtually non-existent. What's real, Dersowitz scoffed, is that 25 million Americans lack required identification. The Brennan Center isn't impartial, and claiming people can't obtain IDs insults voters' intelligence. Crockett's tone hardened. Professor, have you ever represented someone who lost their right to vote because they couldn't afford documentation? Have you met elderly citizens never issued birth certificates? Or minimum wage workers who can't visit ID offices open only during work hours? I have. Calling these real barriers an insult is exactly the ivory tower attitude I mentioned earlier. Sensing he was losing ground, Dersowitz shifted tactics. Anecdotes don't override state authority to preserve election integrity. The Supreme Court has upheld reasonable voter ID laws. Then let's examine that precedent, Crockett replied. In Crawford versus Marion County, the court upheld Indiana's voter ID law because evidence of substantial burden was limited. But when evidence of disenfranchisement emerges, the analysis changes. She held up a document. And in your 2005 Harvard Law Review article, you criticized judges for concealing policy aimed behind selective constitutional readings, using voter ID measures as examples of partisan manipulation. You're taking that out of context, Dersowitz protested. Am I? She asked evenly. Would you like me to read the full paragraph? Let's take a short break, Rebecca interjected. As the cameras paused, Dersowitz leaned toward his aide, whispering urgently, rifling through his papers. Across the table, Crockett calmly sipped her water. When a producer asked if she needed anything, she smiled slightly. I'm fine, but you might check on a professor We haven't even reached the real contradictions yet. When the broadcast resumed, Dersowitz's tone was steady but strained. During the break, I reviewed my own writings, he said defensively. My position has always been that election laws must balance access and integrity. That's what the states are doing. And since we're discussing credentials, he added, turning toward Crockett, I've argued over 50 Supreme Court cases. With all due respect, your short tenure as a legislator doesn't qualify you to lecture me on constitutional interpretation. The condescension was unmistakable. Crockett leaned forward slightly. Professor, she said, voice calm but edged with steel. You're relying on credentials instead of addressing my argument. That might work in a classroom, but this isn't Harvard law, and I'm not your student. Dersowitz bristled. I am addressing substance. Then let's continue, she replied. You claim states should control election procedures. Yet in December 2020, you argued that state legislators weren't bound by their constitutions when appointing presidential electors, a stance that could have nullified millions of votes. She held up another paper. You wrote, the Constitution gives this power to state legislators, not states generally. How do you reconcile that with your defense of federalism? That was a narrow argument about the Electors Clause, he muttered. Both issues, Crockett said evenly, concern the same constitutional balance between federalism and protecting the franchise. But your interpretation seems to change depending on political outcome. The audience murmured as Dersowitz flushed. You often cite Shelby County versus Holder, she continued. But even in that decision, Chief Justice Roberts reaffirmed Congress's authority to remedy voting discrimination, the very authority this bill invokes. The difference, Professor, is that I've represented real voters harmed by those rulings. The studio fell silent. Crockett's gazed in waver. And that, she said quietly, is the difference between theory and lived experience. Crockett listened respectfully before responding. You mentioned your Supreme Court experience, Professor. I respect that. I've worked in state courts where voting rights disputes directly determine whether people can participate in democracy. I've helped seniors reclaim their votes after bureaucratic errors. That's where constitutional theory meets lived experience, not just academic debate. Holding up the bill, she continued, this legislation doesn't federalize all elections as you suggest. It simply establishes minimum standards to prevent voter suppression. States retain flexibility in how they implement them. Moderator Rebecca Mitchell turned to Dersowitz. Professor, your response? The Congresswoman's experiences are valid, he said, regaining composure, but they don't supersede the Constitution. The Constitution gives primary election authority to the states. This bill goes too far. Section 306 alone contains 42 mandates on early voting. That's not a standard, that's a takeover. Crockett smiled faintly. I'm glad you mentioned Section 306. It's modeled on a proposal you endorsed in 1991 congressional testimony. She produced a transcript. You described similar measures as appropriately tailored federal actions. Would you like me to read it? The studio fell silent. Dersowitz blinked, caught off guard. I'd need to review the full context, he murmured. Of course, Crockett said, sliding the document toward him. Take your time. As he scanned the pages, the cameras captured his shifting expression, from confidence to confusion to quiet dismay. This, Crockett said, turning to the audience, is the core of the issue. Voting rights shouldn't depend on political convenience. Some who once defended federal safeguards now oppose them, not because the Constitution changed, but because politics did. Dersowitz attempted to recover. Even if I once supported such provisions, later Supreme Court rulings have refined the framework. Which decisions? Crockett pressed. Even Shelby County versus Holder reaffirmed Congress's authority to combat voting discrimination. That's what this bill does with updated evidence. She leaned toward the camera. The real question isn't theoretical. It's whether every American deserves equal access to ballot, regardless of zip code or circumstance. The Constitution assigns Congress that duty. Dersowitz shifted uneasily. Congresswoman, with all due respect, Section 502 could actually weaken minority voting power. Crockett's smile returned. There is no Section 502. The bill has 428 sections. Perhaps you're thinking of H.R. 2722, a different bill. The audience gasped. He flipped through his papers, realizing his mistake. "I apologize," he said quietly. Crockett nodded graciously. "Apology accepted. I'm happy to share an analysis showing how each section aligns with constitutional precedent. Perhaps we can agree that protecting every American's right to vote is the goal." As the debate ended, viewers understood what they had witnessed, not just a clash of experience versus intellect, but a defining moment where authority gave way to authenticity. Within minutes, Crockett's poise of rebuttal in the Section 502 exchange had gone viral. Crockett's viral clapback dominated headlines as Section 502 trended nationwide. Commentators across the spectrum praised her precision. MSNBC's Rachel Maddow called it David defeating Goliath with surgical accuracy. CNN re-aired the exchange repeatedly, turning it into their month's top segment. Dersowitz, facing a rare public setback, released a careful statement acknowledging Crockett's strong command of the issue. Within days, she was invited to lead a press conference, field national interviews, and even sway undecided lawmakers toward supporting the Voting Rights Protection Act. 3 days later, Dersowitz privately met with her, conceding that her constitutional reasoning was largely sound. Together, they co-authored Finding Constitutional Common Ground on Voting Rights for the Washington Post, promoting debate rooted in evidence, not ego. For Crockett, it was transformative. She became a national voice, proving that preparation and lived experience can rival prestige, and that true authority comes from substance, not status.